Welcome to Law for Life with Georgia.
Welcome to Law for Life with Georgia, where attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Leanne Lyon, and today we're talking about a common misconception in estate planning, that having a will means your family is automatically protected. Georgia's going to explain why that's not the full story, what a trust actually does, and how Wisconsin families can make sure their plans really work when it counts. Georgia, how are you?
Hi, Leanne. How are you? I'm doing great.
Blessed to be here. Excited to see
It's a beautiful, beautiful day. Gloomy out, but guess what? It's a great day today.
you. It's a great day to start a podcast as well.
That's right.
So, Georgia, before we get started on today's topic, that in mind, could you tell us a little about your background? How did you get started in law, and what's kept you focused on keeping Wisconsin families and working with them after nearly 3 decades in practice?
Well, I started out initially, quite honestly, I had a love for acting. So when I was young, I would produce and make these plays and put all my cousins in the production. And so that's where the gift of gab kind of started. And that launched me on into something a little bit greater, which is the legal profession. I went to undergrad at Loyola, University of Chicago. And while there, I took business as my basis. And I thought to myself, I don't know what I'm going to do with this, but whatever it is, it's going to be something. And thank God I did, because that was the springboard that created and allowed me to be able to run my own practice. Having the ability to look at spreadsheets, asset, liability, profit and loss statements, all of that stuff has really helped me in my practice. So my father actually is an immigrant, and he was from Greece, my mother as well. They moved here when they were in their 20s, early 20s. And my father always had this love for the law. In fact, he owned a restaurant. It was called Counselor's Row. And that is where all judges and lawyers went. They would convene there in Chicago, and they would, he just loved watching these powerful people coming in with suits. And you knew that they just had something above and beyond what, like, say, your average business person had. So that's really where it started. My dad had this passion for law and said, you'd be a great lawyer. You always had the ability to negotiate and make things happen. So that's where it started.
When your father tells his daughter that you have a good ability to negotiate, you know you raised him well.
Yes, that's true.
Yeah, it's very true. So then you specialize, though, you didn't go into immigrant law. You went into where you are.
Estate planning, yeah.
What was that
Estate
shift?
planning was,
What drew you
that
there?
is, so our focus, we have a general practice. However, my focus has been on estate planning, probate. We also do personal injury. I've been doing personal injury from day one. That has been a lucrative legal profession for me. And then from there, it just morphed into getting involved in estate planning and probate. Because what I would do is I would settle these large claims. And then these were clients that did not know how to invest their money, how to set up an estate plan and provide for their loved ones, God forbid, should something happen to them. So that's where it just kind of jumped from doing personal injury work to doing now some estate planning as well as probate. So it's become a large part of our practice now.
And before we jump into exactly what a trust is, why do you think so many people still believe that having a will means that their family is automatically protected?
Yeah, that is a fallacy. A lot of people think that because they have a will, they're covered. A will is not enough. What a will does essentially is it basically defines who your executors of the estate are going to be, or executor. In our state here in Wisconsin, we have what's known as personal representative. Because I practice law and I started my practice in Massachusetts, we had different legal terms for identifying the key players in a will. So an executor is very similar to a personal representative. So that is one of the things that a will do for you. It'll also dictate who the beneficiaries are, but it does not avoid probate. And that is critical. And probate, a lot of people don't know what probate means, but essentially what happens is in order for the assets to transfer from the grantor, the testator in this case, to the beneficiaries, the grantor, creating this will isn't enough. What they need to do is do a trust. But a probate, how that works is your beneficiaries have to actually petition the court in the jurisdiction where the party is deceased or dies. And then what they need to do is open up an informal or formal probate, depending on the legal issues and, who in fact are the beneficiaries. So, and the reason why probate is not the greatest thing for people is it takes 12 to 18 months. It's a very long, drawn out process. Some estates can last years, especially if there's a car accident situation where they're still handling the matters. And I've got numerous cases like that, where the estate is held open in order for either if it's a class action lawsuit or if it's a personal injury case, there might still be additional time there. There needs to be additional time there so they could settle the case. So the proceeds then can enter and be put into the probate.
So you just mentioned two things that happen in probate. First of all, they have to petition to open probate. Second, it takes a long time to get through probate. Are there any other surprises that families encounter?
A notice of claims is huge. So what happens is you are opening up, the minute that you open that probate up, there will be creditors that will be filing claims against the estate. These are people that have been owed money, whether you had a $10,000 credit card bill that you owed money to, or maybe you had a ton of medical bills that you owed as a result of your sickness or illness, therefore causing death. But in those situations, there is what we call a claims period. And that is so important because a lot of people will file a claim after the claims period. And what a lot of people don't know is that's something you can try to contest because they missed the claims period deadline. But in most cases, if it's a valid debt and it's something that it's a creditor that is owed money from the estate, they will ultimately win. So that is a big thing. Creditors filing claims against the estate, and then you're opening it up to the beneficiaries actually arguing over the assets. And sometimes what happens is these testators will come into my office and not give equal shares to children. And then the children are salty and they'll say, well, I'm going to contest the will. There's no way that dad would have left you 50% of the assets and me only 25% or whatever the case might be. Right. So there's a lot of litigation that is unfortunately triggered when you just have a will. That's why a will is not enough.
But people often assume that a will and a trust do the same thing. So what's the difference between the two when it comes to who's in control?
Yeah, that is a great question. So a trust, think of a trust like a contract between the grantor, the person who's executing the trust, and their beneficiaries. And it basically gives the control to the person who's creating the trust to be able to dictate the playbook of rules, so to speak. So it's similar to a football field. Let's just, since we were earlier talking about the Packers. Yes, go Pack. And quite honestly, people relate to football. So let's just do football terms here. You think of the trust as though it's a playbook of rules and you're the coach. So the grantor is the coach, the person that is creating those rules. And essentially what they're doing is saying, this is how I want you guys to get the money and how it's going to be distributed. So there may be incremental ages in which it will trigger you to be able to get the money. So for example, at the age of 25, you will get 1/4 of the assets. At age 30, you will get another 1/4 of the assets. It gives the ability of the grantor, settlor, however you want to call it, because in states it's different, whether it's a settlor or a grantor, it's the same thing. It means the same thing. And what that does is it allows them to be able to dictate how the assets are distributed. So think of this. The players are here. You've got the grantor, that's the coach, right? They're the person that's going to execute the plays. Then you've got the trustee. That would be also, you'd call that a coach, and then the coach, unfortunately, if they become incapacitated or they pass, it goes to a successor trustee. So you've got grantors, trustee, and then the trustee gives it to the successor trustee upon either their passing or incapacity. At that point, the trustee would dictate and call the plays, right? So they also would become the referee between all those beneficiaries, right? So the beneficiaries are the players, and the ref's calling the shots and saying, this is what's going to happen. These are the calls. And it's just a playbook of rules. You can have a lot of rules in a trust, including spendthrift provisions. You can have provisions in there dictating about whether you have any substance abuse issues or gambling issues, or maybe you're joining a cult. Those are all types of provisions that you can put in your trust that will protect the assets from beneficiaries who may be negligent.
It's a beautiful thing. I have to tell you, I love having a trust because I knew when my kids were little, if something happened to me, I knew what kind of care they were going to get, what kind of camps they could go to, who they were going to live with. These were all able to be put into the trust that we formed. And it was just a real peace of mind that we had. But another part of it is actually funding the trust, because my saying, I want them to go to this camp and go to these things and fly across the country 3 times a year. Well, there had to be money for that. So can you talk about funding and what that is and how it works for Wisconsin families?
A lot of times lawyers will create these trusts and then just let them go. In my office, when you come into my office, I have you fill out a financial questionnaire form. And that financial questionnaire form dictates a lot of what happens with those assets. Depending if they're qualified or non-qualified accounts, we'll make provisions in the trust for those various assets. It's complicated. And people think that they could go online and just get something and piece it together, slop it together. It doesn't work that way. You know, just like you don't you don't try to care for yourself. You go to a doctor to get the care, right? You leave it to a professional juris doctor to actually make and help you navigate those important decisions. It requires professional help. It is not something you can navigate online on your own.
But when a trust is funded properly, how much faster can it go for the family when the time comes?
So what we do is, getting back to that question, in terms of funding, we take the assets and throw them into the trust. So the trust then points and has the steps and the keys that happen. Like what, for example, say you have a bank account, and what you do is you add for the beneficiary the trust. So you name the trust as beneficiary of that bank account. Then what happens is it's called funding. The trust now has been funded with that bank account. Those proceeds are going to transfer into that trust and avoid probate. You don't have to go to probate in order to get that bank account. That's just one of many assets that you might have. So what you're doing essentially is, when you're funding, you're avoiding probate. That is key. And a lot of people they miss that step. That it's absolutely important to make sure you throw the assets in your container. Okay. And the trust is similar to a container. You got to throw the assets in there in order for it to be properly funded.
Which, to bring us back to the beginning, is a big difference between a will and a trust. So
Absolutely.
as we're wrapping up here, can you share a story, without names, of course, of someone who thought that they were protected but learned the hard way that a will was not enough?
Yeah. I had a situation, unfortunately, where The husband and wife married for 30 years, and the husband did not even have a will, had nothing in place. Now, mind you, they owned a home for over 30 years. And in that scenario, the house, unfortunately, when she paid it off and talked to the bank came back and said, well, your name's not on the title. And it was an absolute nightmare of a situation because it was a blended family. So you had a situation. She had no children of her own. He had 2 children of his own from a prior relationship. Now, those children ended up getting 50% of the house, and these children were estranged from their father. For over 30 years, there was absolutely zero communication. Turns out one of those kids now has passed away, and now we had to deal with an estate. So it was an estate as well as a child who was living in a different state. And it was just an absolute mess. We had to go to court. And the children wanted as much money as possible extracted from the equity in the house, because the house had been paid off in full. So it was an absolute nightmare of a situation. That was an intestate situation. We had another situation where it was an actual will that they had in place. However, as I'd mentioned earlier, they didn't have equal distributions in place. So what happened in that case is some of the beneficiaries, there were 3 beneficiaries. The one son received 50% of the assets. The 2 daughters only received 25 apiece. So they contested the will and claimed that the testator was not of sound mind when they drafted this will, and therefore the will should be thrown out and the assets should be divided equally, 1/3 to all 3. And it took a lot of time, a lot of money. The legal fees were astronomical. And in the end, the only person who won was obviously me, the lawyer. So I hate to say it. And that's why drafting is really important, making sure that the person that's sitting at your desk understands, if you're wanting to have a fight here, there will be a fight, especially when you don't do equal shares. You need to identify it, and then you need to put clauses in there that protect against that if someone does try to contest.
Yeah, my heart just hurts to hear these stories because it's so avoidable when they work with a competent attorney such as yourself to take care of this in advance, get it in writing, get it all set up. And that's what this is all about. That's it for today's episode of Law for Life with Georgia. To learn more about Attorney Georgia Konstantakis and Konstantakis Law Office, LLC, visit konstantakislaw.com. And thanks for listening. Be sure to subscribe, share, and leave a review if you found this episode helpful.
Thank you, Leanne.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.